most of you know the US is very litigious, not just in the securities realm, but in general. And there are a lot of reasons for that. And some of those reasons are specific to the securities realm. But let's start by talking about why is the US so much more litigious than many other countries? And how does that translate into the securities litigation exposure that directors and officers of US listed public companies face? And I would say there are a number of reasons why the US is uniquely litigious. The first, and perhaps the most important, is cultural. I mean, we have a culture in the US where it's very important for purposes of public dialogue to assign blame. When things go wrong, it's kind of a habit in the US that somebody must be to blame and we need to figure out who it is. And that sort of blame casting instinct, I think, permeates litigation, not just in the securities realm, but in consumer protection, product safety, a variety of different liability realms. If there's a good side to this, it's that litigation as a tool of blame assigning is designed to try and have a deterrent effect. The prospect of litigation liability is hoped to have an effect to deter conduct that's viewed as objectionable. And so that cultural backdrop kind of gives a setting for the specifics of the securities liability regime. I'm going to be talking more in a few minutes about how, as a result of the Great Depression and a perception of abuses in the securities markets, the US adopted the foundational securities laws that are the basis of the liability regime. But in addition to that heritage from the Great Depression, we also have the common law heritage. The US was, of course, a British colony before becoming independent in the 18th century. And we carry, as a result of that colonial tradition, the common law heritage. And that's particularly important in the securities litigation realm because although the basis of the securities laws in the United States are statutory, much of the law that's relevant to securities liability was developed through case law. And so case law developments are critical to understanding the nuances of the securities liability that directors and officers potentially face. There are other sources of the litigiousness, particularly in the securities arena, that help explain why the US is so litigious and arguably more litigious than any other country. And one is the jury trial tradition, which again is part of that common law tradition from the British legal system, but also perhaps distinctly the US and all 50 states in the US permit contingency fees, which creates financial incentives for plaintiffs' lawyers to be willing to pursue claims. I don't have a bullet point here, but I think it's relevant that the US is not a loser pay model, as for example, in the UK and other countries. In the US, we follow the so-called American rule, which means that each party bears their own cost. So there's less disincentives to prospective plaintiffs for pursuing their claims because they don't have to worry about possibly having to pay their adversaries' costs. Our class action model is an opt-out model, which means that presumptively classes that are the basis of a class action lawsuit are large and aggregate many smaller losses to create a larger loss, which again creates an economic incentive for the plaintiff's lawyers to pursue the claim. And then as a result of that case law development, we have something known as the fraud on the market presumption. It basically relieves plaintiffs from having to show that they themselves individually relied on the alleged misrepresentation or omission. They can instead rely on the fact that in a market traded securities system, that investors rely on the integrity of the market and they rely on the truthfulness of all the information in the marketplace. And all of that is packed into the share price, and the share price at any given time reflects all of the publicly available information about a company. So if there were misrepresentations or omissions, those misrepresentations and omissions would be baked into the share price on any given moment. And a buyer in that marketplace would rely on the share price as the sort of summary of all the known information about that company. The fraud on the market presumption is an important component of the ability of plaintiffs to be able to pursue these claims. And I'll come back to that later when I'm talking about the elements of securities claim. Another aspect of the securities arena in the United States that's important is we have a specialized entrepreneurial plaintiffs bar in our country. The top lawyers in the securities arena are very good. They're excellent lawyers. They're also opportunistic, and they're willing to take chances in order to reap entrepreneurial rewards. So as a result, they are willing to push the envelope, to test new legal theories, to try new kinds of claims, and they're constantly expanding the frontiers of what can constitute an actionable claim in the securities arena. And the existence of that specialized plaintiffs bar means that the threat of securities litigation is constant and reliable. You know it's going to be there. It's not going to go away. And it's something that companies need to be aware of and take into account in their disclosure practices and other corporate activities because of the omnipresence of that plaintiffs bar that's active in this arena. Now,
Kevin, I just had just a very quick comment on this,
sure.
this background. Sorry to interrupt.
Sure,
when I
fine.
was doing the research for the presentation, I also have the impression that the securities market is so dynamic and big in the US that it's a part of the life of the US. So there's so many listed companies. So there, when I was doing the research, even before the crisis of 29, there were a lot of issues with issuers who were abusing the market, so that also contributed to develop all these trends in the securities litigation.
It's true, Arturo, and it's a good point. It's not just that the stock markets are such an important part of the financial system in the United States, but also share ownership is widely dispersed. Many individuals in the US have individual retirement accounts that often are invested in securities, either directly or through mutual funds. And so share ownership is very widely dispersed. And so when there's a scandal, it affects a lot of people, and a lot of people get angry. And that, I think, contributes to the prevalence of securities litigation, particularly when taken in conjunction with that blame assigning culture that I talked about before. So it is a good point, Arturo, that securities markets are an important part of the US economy, and share ownership is widely dispersed. And those two things do contribute to perhaps a greater willingness to resort to securities litigation than perhaps is the case in other countries.